The latest term of parliament, which ended last week ahead of the upcoming elections in June, will go down as a black mark in the history of democracy in Turkey, with parliament having passed many laws that have dealt a huge blow to democracy and freedoms. Parliament, which began its 24th legislative term following general elections in 2011, took steps in the past 4 years such as amendments to the Internet Law, the introduction of a domestic security bill, extra legal protection provided to members of Turkey's intelligence agency that have paved the way for a police state. But the biggest shame on the current parliament, on the ruling party deputies to be more precise, will be without doubt the whitewashing of 4 former cabinet ministers accused of corruption, the biggest graft case in the history of the Turkish Republic. Turkey will have parliamentary elections on June 7 and political parties are expected to launch their election campaigns in the second half of April. Parliament whitewashed cabinet ministers. On the morning of December 17, 2013, Turkey woke up to news of a huge corruption operation, as part of which a number of prominent figures, including the sons of 3 then ministers, who also left their posts after the probe went public, were taken into custody. A second major corruption probe launched on December 25 that same year could have possibly landed then Prime Minister Recep Tayyip Erdogan and his son Bilal, among others, in custody if the judicial process had not been blocked by the government. Despite the fact that 4 cabinet ministers, whom the police were unable to detain due to their legislative immunity, left their posts following the first probe, the government came up with an inspired idea to weather the sweeping allegations of corruption. The brilliant government, headed at the time by Erdogan, who is now president, labeled the graft probes as a coup attempt against the government. Then, all the prosecutors and police in charge of the corruption probes were removed. The newly appointed prosecutors, despite charges backed by blatant evidence of corruption, at the end of last year dropped all the charges of corruption against suspects without feeling the need to bring the charges before a court. The only way for the 4 ministers implicated in the probe to be legally clear of the charges was to be sent to the Constitutional Court for trial by Parliament. Under pressure from the opposition, Parliament established, with much delay at the end of June last year, a commission to look into claims of corruption against the 4 former ministers. But the establishment of the commission, as well as its further program, was continually delayed by the ruling Justice and Development Party, AK Party. The ruling party had a comfortable majority both in the commission and Parliament. As expected, both voted at the beginning of the year against the referral of the 4 ministers to the Constitutional Court, sweeping claims of corruption against the ministers under the carpet. There were claims of President Erdogan having exerted heavy pressure both on the government and on ruling party members of the commission for a non-referral. According to the main opposition Republican People's Party, CHP, the total amount involved in the alleged government corruption could be as large as TL $247 billion, $113 billion. The vote in Parliament, which resulted in the failure to refer the 4 ex-ministers to the top court, prevented the allegations from being heard by a court. Fundamental rights threatened by the Security Bill, a domestic security law, much criticized for paving the way for a police regime as it bestows extensive powers to the police and governors, represents another major disgrace for Parliament. The law, which Parliament passed last month, has been blasted for dealing a blow to democracy and fundamental freedoms such as the right to life, right to demonstrate and right to privacy. The opposition, which maintained that the law is against the Constitution, said it would take it to the Constitutional Court. According to the law, police officers will be able to take under protection anyone who is considered to be a public disturbance, or threat to security or private property. Police will no longer need a court order or prior approval from a prosecutor to take a person under protection. Under the current legislation, police officers cannot detain an individual without the permission of a prosecutor. Now police officers will be able to keep a person in custody for 24 hours without requiring the authorization of a prosecutor. However, in cases of mass demonstrations the detention period will extend to 48 hours. As per the law, governors will be able to instruct the police to go after the suspects of a crime. This is a violation of the principle of separation of powers, Attila Kart, a CHP deputy told today's Zaman. noting that it is a parliament under the tutelage of a government that does away with fundamental principles of parliamentary democracy and that the constitution is based on the separation of powers. Card added, Parliament served as a tool for the suspension of the constitution. The law also provides that those who take part in public demonstrations or rallies with their faces partly or totally covered to conceal their identity could face sentences of between 2.5 to 4 years imprisonment. Police are now authorized to shoot at protesters to prevent them from even harming property, while, according to current legislation, police officers are only authorized to gradually increase the use of force to prevent a crime. Police officers will be able to search people and their cars based on reasonable suspicion without requiring prior authorization from a prosecutor. They are even authorized to conduct strip searches according to the law. The bill also allows police officers to wiretap telephones for 48 hours before a court order is issued. The police will need to submit a request for a wiretap within 24 hours, but the judge is only required to deliver a judgment on the issue within 48 hours. Currently, a judge needs to rule on the issue within 24 hours. Despite being the institution that must have particular care to respect the Constitution, Parliament worked in favor of the interests of some of these in the ruling party. Yusuf Halalu, the parliamentary group deputy chairman of the Nationalist Movement Party, MHP, told today's Zaman. Government tightens grip over the judiciary. Following the graft probes of December 2013, laws have been passed that put the judiciary under tighter government control. Shortly after the probes, Parliament passed a law that allowed the government to restructure the Supreme Board of Judges and Prosecutors, HSYK, the country's top judicial body, which is responsible for the appointments and promotions of judges and prosecutors. Some of the amendments introduced did away with judicial independence by putting the HSYK under the control of the Interior Ministry. However, the main opposition CHP filed an appeal with the Constitutional Court against the HSYK law, and the top court partly annulled it in April last year. In its verdict, the court nullified the articles granting extraordinary authority to the Justice Minister over the HSYK, such as the appointments of judges and prosecutors by the minister. In an effort to strengthen its grip over the judiciary, the HSYK was given the authority to decide which court will hear which legal cases. Based on this authority, the HSYK established in February special courts that are expected to give verdicts that would please the government. The intelligence agency's authorities were extended, according to amendments Parliament introduced to the law relating to the National Intelligence Organization, MT, in April 2014. MT agents operating under an assumed identity will not be held accountable for their activities, and MT agents who infiltrate terrorist organizations will have no criminal liability for crimes committed while undercover. Such a legal protection is feared to pave the way for hitmen for the ruling AK party. The bill also authorizes MT to conduct wiretappings without a court order. MT will be authorized to wiretap phone conversations overseas upon the orders of the Undersecretary or his aide. MT will have unfettered access to the archives and databases of every ministry, and it will be able to collect data on citizens. What is more, the law requires private companies to hand over consumer data and technical equipment when requested by MT. Internet censorship. Since the anti-government Gezi Park protests of the summer of 2013, but more so following the graft probes, the government has become allergic to criticism on social media. Parliament recently passed a law that authorizes the government to ban websites for 24 hours without a court order. The bill, which was adopted last month, gives the Prime Minister or a relevant cabinet minister the ability to ban a website or have specific content removed when public order or national security are at stake, as delays in having to obtain a court decision to do so are inconvenient. According to the bill, when there is online content that threatens people's right to life, threatens their security or property, threatens national security and public order, poses a threat to general health or threatens people's rights and freedoms, then the Telecommunications Directorate, TB, will demand the content be removed or block the website upon a request from the Prime Ministry or the ministry relevant to the case without seeking a court order. One government attempt to ban access to websites failed in October of last year when the Constitutional Court overturned an amendment that gave the state-controlled TB the power to block access to websites without a court order. The TB was already authorized, based on amendments passed in Parliament in February of last year, to collect Internet traffic data from Internet service providers based on a court ruling reached as the result of an ongoing legal investigation. In the February version of the Internet law, the TB was granted the power to block access to any content on a web portal without a court order, but only if the content constituted an invasion of privacy. Abolishment of prep schools. Parliament also passed a law in March of last year that banned prep schools without any valid reason. According to a report released by the Istanbul Institute's Center for Social Policy Studies in January, the ban is unconstitutional in a number of ways. According to the law, prep schools will no longer be able to operate as such after September 1, 2015 and must convert to standard high schools if they wish to remain in operation.